The National Schools Debating Championships 2022 would like to thank our premier partners, the Australian National University and Crimson Education, our major partner, the University of Canberra Faculty of Business, Government and Law, and our sponsor, Speaking Schools Australasia, for their support in making this tournament happen.
Yeah.
Yesterday, 46 people were killed in a prison riot in Ecuador. They were killed because Ecuador's legal system was backlogged, because they were languishing in a jail waiting for a trial that was probably going to be rushed, probably not going to be very fair. That was the cause of the backlogged legal systems that are the scourge of the world. Not only are plea bargains an essential component of a legal system that values choice, they are also a necessary remedy, a necessary backstop to courts that are overworked in this way. Three things I'm going to tell you in this speech. Firstly, when this is used. Secondly, why it matters so much for consent. And thirdly, why we get better justice on our side. I'd also quickly note, obviously, we're happy to support other things related to plea bargains that currently exist in legal systems. That's things like having a judicial review. That's things like you have to see all the evidence used against you. You have to understand the terms of the condition before you sign it. All of those we're happy to support. I'm about to go on to when this is going to be used, but before we do that, I'm happy to take a point in like 5 seconds, so it becomes a minute. No, all good? Okay. First issue is, when is this going to be used? I think the first thing to note is, obviously this is offered relatively often because the state has somewhat limited resources. They obviously like to prioritize those resources on cases of high import or cases where they might lose. They're likely to offer this in a significant number of cases. No, thank you. Secondly, and where the debate largely takes place, is where defense lawyers advise their clients to take this. Note, obviously, in the case of private lawyers, that's an easy win for us because private lawyers have both the incentives and a significant amount of capacity to advise their clients well. Where this debate really takes place is in public defenders. I'd like to note, we think public defenders are broadly good. It is an incredibly prestigious role to get coming out of law school to go into the public defense system. The problem with public defense is you are overworked by overloaded courts where you're often running 5 or 6 cases at once. That means not only do you get worse outcomes because you're busy, but also there's more attrition from the profession as people go to easier jobs. No, that weaponizes anything Nate might say about public defenders being bad, because clearly they're worse under a side that is less efficient. Final thing I would note is we think public defenders likely advise their clients in quite good ways. That's because A, we just proved that they have quite a significant capacity, but also they have a strong incentive. That's because they have incentives to success, both personal, because they want to win more cases, get a better number of cases won, but also altruistic. You go into the public defense. If you are someone that tends to be quite altruistic, you tend to care about your clients. Note, obviously, you also have legal obligations to your client. You probably want to fulfill those. At the end of this point, you should believe that even though the client is the one who is choosing this, the public defenders, the private lawyers, anyone that is advising them is likely giving them good advice. I'll take a point now.
Yeah, does your side value efficiency over false guilty verdicts?
I think the thing to note is that's a false dichotomy, because when you have an inefficient legal system, clearly you get worse justice in most cases, because an inefficient legal system means less time spent in trials. It means that the witnesses that are called are not cross-examined as well. It means that you're languishing in jail for a longer time. Those two things are not distinct. If you have an inefficient legal system, you obviously get worse cases. I'll deal with the intimation that you get fake guilty pleas, that you get problems. I'll deal with that in my later points. Okay, the first key crutch of our case is that this is a key part of consent. Note that obviously we suggest that the incentive for you to choose well is there. That's because the incentive is that you don't want to go to jail for the first time. You don't want to sign an agreement that sends you to jail if you could otherwise have got out of it. Clearly, the average defendant probably will choose well, probably has an incentive to choose well. Therefore, why do they have the capacity to choose well, the capacity to make an informed consent decision? We give you 4 reasons. The first is, as I proved earlier, you get good advice. Whether you have a private lawyer or a public defender, the advice you are getting is probably quite good. Secondly, note you get state support. That's because you have things like legal requirements. You have to understand the conditions of the agreement. That's because there's legal requirements, like you have to be shown all the evidence that might be used against you. That means you have some sort of capacity to understand the case that would be coming ahead. Thirdly, that's because you have relatively more power symmetry when you are in a courtroom. When you are doing a plea bargain than in a courtroom, that's because there's a lower barrier to entry to just understanding a sheet of paper that says these terms and conditions, rather than understanding an entire court process, rather than having to try and use the resources on a whole court process. Finally, I know that defense often use plea bargains as well. That probably indicates that to some extent there are many people who choose to do this. The importance of that is that means that you can make an informed choice to take a plea bargain. That choice matters a whole lot because all all the time in the legal system, we defend your right to make bad choices, even if they're bad, as part of your legal system. We defend your right to defend yourself. We defend your right to stand yourself on trial. We defend your right to drop a trial even though you might win it. We defend your right to plead guilty even though you might win a trial. All of these are reasons to suggest that the legal system values choice. It values individual choice. I think that's debate winning because that implies that you have some degree of individual choice in every part of the legal system. We should also implement this here in this particular case. Final argument is why you get better justice in the legal system. I want to note that this is going to take part on two levels. Firstly, a more efficient legal system, and secondly, a legal system that is far better than trials. First, on the efficiency, I want you to note in the status quo, the legal system is incredibly overworked. That is to say, crime is rampant, especially with economic downturns, especially after COVID, but also the state is better at policing, so there's just more cases piling up. Note that's, for example, the fact that the New South Wales Family Court has a backlog of 1 year, which means if you want to go to trial, you have to wait a whole year before you're actually seen. Note that obviously also this debate is not place set in Australia. Negative also have to deal with cases of countries that have more broken systems. I told you about Ecuador, but also systems which do not have plea bargains. Clearly those are even better for our side. Note that those two things tend to be conflated because less developed countries have less developed legal systems. They don't have the infrastructure necessarily for plea bargains. Why do you get a more efficient legal system? I think that's incredibly intuitive because if you have less cases on the docket because some of them are resolved out of court, you no longer have to deal with those cases. You can spend more time on the other ones. So thank you. Impacting of that efficiency. Note that even if you go to trial in one circumstance, that takes up a whole lot of time. You have to call witnesses. You have to have a verdict. You have to do all the necessary parts of a trial that mean you can take months or years when a case could be resolved in a few days through a plea bargain. Note also, this responds to what they intimated in their POI, because every loss of a plea bargain means wasted time, and that wasted time is worse cases for absolutely everyone else. That means more waiting. So like the Ecuadorian inmates who are waiting in jail for years and years before you're even seen. That means a more rushed court system. And indeed, if negative want to talk about public defenders being bad, that means worse public defenders, because if you do not have plea bargains, public defenders will have even more dockets to deal with. Note also that this exists on two levels, both in countries where this already happens, where you already have plea deals. We think those plea deals are probably a backstop against the system getting worse. In countries, no thank you, where the plea system does not already exist, we probably help solve that problem. Note that the comparative here is that negative are never able to deal with this inefficiency that is so inherent to the court system, because that inefficiency, we target the root cause of that problem. The root cause is that you have too many cases to deal with. There's absolutely no way to deal with that without taking some cases off the docket. We do that. The way in here is what I said earlier. You get less good justice when you have an inefficient legal system, but also you get less good justice on the most important cases, because the cases that do go to trial are probably those cases that really need to be seen, that are really contentious, that are really close, and that have a high import. Clearly that matters a lot. Final issue is dealing with why this is better than trials, and what this essentially says is any mech that negative need to give you, they need to show why the trial system is not worse. Think about it. If you have bias in the current court in a police bill, it's going to be worse in a court where there's judges, where there's evidence, where there's witnesses, where there's a jury, all of whom can also be biased. And also, when it is less tangible, there's no terms and conditions to see bias in. Note that if a power asymmetry exists, and negative wants to talk about that, that power asymmetry is worse in courts, where you need resources, where you need a vast amount of time to spend in trials. So therefore, a more powerful corporation that is suing someone has much more power in the court than outside it. Finally, note, if they want to talk about a lawyer being bad, note that obviously your lawyer is going to be far worse in a court where the lawyer has to do vastly more things than just advise you on whether you should or should not take the plea deal. At the end of that, you should note that whatever the negative need to do, they need to provide a strong comparative for, because the court system is so much worse than just taking a plea deal. At the end of this speech, you should believe that public defenders, private lawyers, no matter who you're taking, you get a better outcome when you take a plea deal. You get a better outcome when you can choose to take a plea deal. Thank you.
Panel, I'm going to start by rebutting a few of the points and then move into my setup. So first, the idea of whether the defendant is more informed in a trial or in a plea deal, and whether the power imbalance is better in a plea deal or a trial. So on this idea of the power imbalance, the only people significantly involved in a plea deal are the defendant and prosecution, counsel, the judge who carries out sentencing, and the defendant. We believe that if the defendant is a minority, if they are low SES, if they do not have English as their first language, then they are sitting in a room with a bunch of educated people who are vastly above them in terms of their understanding of the law, and thus the power balance is clearly worse here than in a trial system where you have a jury of your peers, of people that are not necessarily educated in legal knowledge, who can more accurately represent the defendant. On this idea of the information imbalance, that as they brought you, that the defendant would be signing more forms in court, and thus that someone who doesn't speak English as their first language would be worse off. We believe.
Point.
No, thank you. We believe that this is a symmetrical harm, as both sides have paperwork that is signed. It's not necessarily worse off if you have to sign one piece of paperwork rather than 10 if they all have essentially the same outcome. But we do believe that the paperwork you sign in a plea deal, a piece of paper that essentially says, without a trial, whether you are guilty or not, is far more significant than all of the assorted paperwork. You might have your lawyer sign no thank you in trial, and thus that the information imbalance is worse on their side of the house. Second, we believe that the definition of what we have to address here is slightly unfair. We think it's completely unfair for us to address every single legal system in the world when talking about plea deals. Because not only do they have different laws, different justice systems, they have completely different plea deals. It is impossible for us to address all of them. So on this side of the house, we are going to keep the scope of this debate within Australia.
Point.
No, thank you. And lastly, on this idea of efficiency. So they propose that their system is more efficient. We agree it will be faster, but it is a short-term solution that does not fundamentally change the justice system in any meaningful way. It is, as I will tell you later, unfair. I will tell you later, it decreases the respect of the justice system as an institution, and therefore, no thank you, you get worse outcomes. So on my point of setup, 3 points, where are plea deals used? 2 points, where are plea deals used, and what does the affirmative team have to prove? On this first point, we think plea deals are used in 2 places, and are not used in one significant exception. Number 1, plea deals, no thank you, are used in mid-level courts with ordinary people who have committed serious crimes. We believe this is unfair on them, as they have a significant incentive to get the least amount of jail time possible without necessarily being informed about the law. They also likely have access to less quality representation. This might look like public defenders. This might look like low-tier paid lawyers, which means that there is, no thank you, significantly more encouragement for a plea deal because of these overworked public defenders, as this had acknowledged, and the lack of skill that these low-tier paid lawyers who they can afford might have. The second place that plea deals are commonly used are in local courts, and we think this significantly impacts minorities, low SES, and English as a second language people. Because they have less education and often a public defender or an overworked representative, they are essentially sacrificed for the efficiency of this court, no thank you, and they are coerced because of their lack of understanding of the law into taking a plea deal when they might well be not guilty and might be found not guilty by the court. And on the last point, we believe that plea deals are not used in high-profile cases because these people generally have the means and the reputation to uphold, and therefore they're not going to no thank you, take a plea deal, plead negative, and finish. So on to my second point of setup, what does affirmative have to prove? We believe fundamentally that they have to prove that they get better justice. This looks like minimization of false convictions in the justice system, and this looks like the evolution of justice. We think that they should have to prove that they can change the justice system, improve it for the current world. This looks like creating case law that allows the legal system to expand. I'll take a point.
Should we use juries to prosecute petty theft?
I believe that we should use whatever is practical to ensure the best outcomes for the defendant. I believe that if we have to, we should use juries to prosecute petty theft, because that is the only way to ensure a fair trial for the defendant. Now, onto my substantive, I have 2 points. Our principle of fair justice and the effect on a number of stakeholders. My second is going to show you how we reform the legal system for the positive. On my first point, our principle of fair justice. 2 points on this. What does fair justice look like, and why is fair justice more important than efficiency? So what does fair justice look like? 3 things. A trial by your peers, quality representation on all sides, and the idea of being innocent until proven guilty. We believe that for trial for your peers, it's fairly evident. If you have people who are of similar backgrounds to you, who are of similar legal knowledge to you, they have more understanding, and therefore they're able to better take in the facts of the case. This looks like juries who are able to give fairer outcomes to the defendant because they can understand them more effectively. Opposition essentially stands for a trial by lawyers, where low minority people are presented with a form they may not understand and are given no way of showing to people like them why they might be innocent. No, thank you. On the second point, quality representation. We believe that there's a spectrum of lawyers, from low-end public defendants to high-end, high-paid lawyers, but we always believe that representation should be in your best interest. As opposition conceded, public defenders, while they may wish well, are often severely overworked and therefore might choose to sacrifice your case by encouraging you for a plea deal to save time. No, thank you. And on to this third point, innocence until proven guilty. We believe this fundamentally cannot exist under a plea deal system because if you have no trial, there is no way to fundamentally prove that this person is guilty beyond a reasonable doubt, and the same goes the other way. They might be coerced into it by their lawyers, as I already said. And the second point, why is fair justice more important than efficiency? 2 points on this. What does fair justice indicate? And why does their counterfactual nothing do result in a lesser reputation for the legal system? On this first point, we believe that fair justice fundamentally creates trust in the legal system. Because if you see your mate go into court, spend perhaps several weeks in front of a jury pleading the case and get a fair outcome, you are far more likely to have trust in the legal system. And you are likely to believe that if you were convicted of a crime, you will get the same trust. We can see that this trust may look like fear. You may be scared of court, but we fundamentally believe this is a good thing because we want to minimize the amount of times you come into contact with the legal system. However, if you do in fact come in contact with the legal system, we believe you should get the fairest trial possible. On to the second point, why does that counterfactual result in a lesser reputation of this legal system? No, thank you. Number one, a plea deal is very closed doors. It is not transparent at all. This means that the public who is unable to see the outcome, and they may assume that it's completely unfair, and thus have less respect for the legal system. This looks like two things. Less likely to go before the justice system, less likely to call the police if they have had a crime committed to them because they don't trust the system, and less likely to cooperate with police if they are called as a witness or required to give information. So on to my second point of standard, the effect on stakeholders. 3 stakeholders here: minorities, low SES and low literacy, and victims. On to minorities. They are harmed because there are no trials by their peers. They are tried by lawyers who are often of a different ethnicity or a different background to them. As I've already proven, this fundamentally means that they cannot get a fair outcome, and they are more likely to spend longer in jail for crimes they did not commit because there is less understanding, whereas they may have walked free because they did not commit the crime if put in front of a jury of their peers. And the second point, low socioeconomic and low literacy, as I've already proven, they're more likely to be pressured into plea deals because they have low literacy and often bad representation who are overworked. They can't understand the forms they're being given, and they are often sacrificed for efficiency to keep the public defenders moving, which means worse outcomes for them. And on this final point, victims, number one, plea deals often result in worse sentences for those who are actually guilty, which means that they do not get the justice they deserve. And number two, less evidence is presented before the court they're already proven, which means that some cases may not be able to be taken to trial because someone who was scared of the legal system did not give evidence. Because of all these benefits, so proud to negate. Thank you.
This team needs to be comparative because almost everything they said as that was a problem with the current system was equally, if not worse, under their side. They tell you minorities. They tell you lack of access if you can't speak English. Think about how different that is in a courtroom. They wanted to say, well, people can be biased. Think about judges and lawyers who are trained to ignore those biases versus a jury of 12 of your peers who are not trained to ignore that bias. That's the world that they stand for when they don't support the use of plea bargains. Before I get into my speech, one thing, we'd just like to note they obviously can't place set this debate in Australia, but note even if they did, we'd still win. We tell you all of the problems that we outlined do exist in Australia. We think we can still win this debate that way. 3 things I'll do in my speech. Firstly, a question about consent. Secondly, on justice. And finally, a piece of substantive about why this is particularly helpful for certain types of victims that side negative ignores. Firstly, on the idea of consent. And their main push here is that people are uninformed because they are, for example, unable to read, for example, or maybe they, there's a power imbalance and therefore they cannot access proper legal advice. First thing to note is that this obviously ignores the characterization we give you, which suggests that public defenders are not people who are unskilled, but there are other reasons which make that profession look less appealing. That's, for example, the hours you have to work, the time that you have to invest, for maybe limited outcome in terms of pay. This suggests that, for example, when they wanted to tell you public defenders were bad at that job, that was not true, which meant, firstly, public defenders obviously were very good and able to inform you accordingly. But secondly, we also told you that there were legal obligations which meant you were informed. That was firstly, the public defender's legal obligation to inform you accordingly. For example, if they didn't, they could be disbarred. But secondly, legal obligations that meant you had a right as a defendant to see the case against you, you had a right to see the evidence against you, which gives you the ability to make a calculus in your head about even if you're ignoring what your public defender says, assuming they are not good at their job, you internally are able to make the calculus about whether or not you think you're going to have a good or bad chance at trial, which is why you do have the ability to make informed. But thirdly, we obviously know that this is just like worse at trial, because assuming that, for example, maybe your public defender is bad at their job, or that you are unable to make good like decisions in your head, know how much worse that would be at trial, because it means that that public defender now doesn't just have to like negotiate a piece of paper, but they actively have to do things like cross-examine witnesses, find evidence. If you're assuming that a public defender is bad and you buy this flawed characterization, obviously the harms are much worse on their side if you wanted to stand for things like trials. Final thing I'd like to note is how it doesn't respond to a lot of the material we give you, which suggests that firstly, people are obviously not like going to willy-nilly make this decision. Going to jail is a big decision, which suggests that people put a lot of attention and care into making this decision that went unresponded to. What is the impact of this argument? Firstly, it explains why people have a right to choice in the sense that they can consent to this decision, and it also responds, no thank you, to a lot of their material, which suggests that, for example, innocent until proven guilty is like a principle of the justice system, at the point in which we tell you someone consents to necessarily taking a plea bargain, even if, for example, they think they are innocent, we necessarily allow them to do that. For example, we brought you that people can represent themselves even though they might not be qualified, but we still let them do that because we respect people's autonomy in the justice system. That's why people can consent, and that's why you ought to wear that material highly in this debate. Next question of rebuttal on justice. And again, we're going to examine this through two lenses. Firstly, in terms of efficiency, and secondly, in terms of justice in courts. First thing on efficiency, and I'd just like to get this out of the way, because firstly, they largely agree that efficiency is like a win for our side. They sort of admitted that. But note that they would stand for a world in terms of the one that prioritized justice over efficiency would just be like completely inefficient. Like when we brought you the PY about petty theft, they were like, sure, we can use juries for petty theft. Just think about how unreasonable that is. Summary offenses and courts that don't have juries exist for the sole purpose that it is simply a waste of time to get juries, because like it's a summary offense, like the evidence already suggests that they are guilty. Obviously, this is also another example about why innocent until proven guilty is sometimes ignored in our justice system, because obviously there are other factors we need to take into account. We think that this is a huge win for us, and the reason why you ought to give this a lot of weight is because efficiency is a prerequisite to a lot of their benefits. Why is this true? Firstly, again, if you buy their flawed characterization that public defenders are bad at their job, and that, for example, also they don't have a lot of time, at the point in which you have a public defender who now doesn't have to handle as many cases because some have been plead out, or a system that doesn't have like hundreds of cases in backlog, that public defender is able to do their job better, which meant even if you went to trial under their side, you're going to have a better system. Secondly, it tells you that more people get access to the system because, as we told you, less people have to wait for a trial. For example, like the minimum like wait on trial if you're like denied bail in jail is like 3 months in Australia. These are people who have not even had their day in court but are still being held in jail. That's the world that they stand for. Any benefit we have here is huge because it explains why more people get access to justice. And note that like this obviously resists like no thank you lies on a flawed characterization or premise, which is to suggest that like plea bargains are not just. Like we definitely think plea bargains are just. They can't run away with that. Final thing then on justice, and this is about like power asymmetries and like people who are not guilty but are found guilty. Two responses. Firstly, the types of people who take plea bargains are ones who are not likely to win a trial. This was the characterization we brought you from first. But why was it true? A, we told you lawyers, for example, public defenders, are quite good at their job. But at the very minimum, even buying their characterization, if they are confident in their case, they're not likely to take a plea deal because they think that they're going to get a win. This is especially true for a public defender who, for example, as we told you, is someone who's quite motivated and passionate and does believe in that case, since they're probably entering that position not for the money. Secondly, we tell you that, like, for all the reasons we suggest, it is unlikely and very minimal that the number of people who take these bargains will win at trial. But because we told you people consented to this, they necessarily gave away their right to have an innocent, or they necessarily understood they were giving away their right to not be put in jail at the point in which they agreed to this. Second response is to do with minorities, and they say minorities are just like really bad and they're like going to be destroyed under our side. Note how uncomparative this is. As I flagged in my introduction, one, assuming a judge or, for example, a country is biased against a social minority, think about judges who literally have to like go through being a lawyer before they have to become a judge and are trained at every step of the way to not be biased, who also are subject to things like judicial reviews which test how biased they are in a courtroom, versus a peer of 12 juries who are often selected by the state to be biased against a defendant, and you expect those people to be unbiased and to ignore those biases. Obviously, that was uncomparative. Secondly, we tell you that your minority status also manifests in financial ways, which suggests that maybe you cannot pay for the best lawyers, again, going with public defenders, which suggests that you have less access to resources, for example, to go against a state that is funded by the government, one that obviously has things like people who are unlikely to take cases to trial unless they're confident in getting a guilty verdict. That's why minorities are also win for us. They need to be more comparative. Final piece of substantive, but first I'll take a point.
Yeah, do you not believe that even as both the state and the defendant's lawyer can reject jurors, that the jury system is relatively impartial?
No, because there's like a limit on how many jurors you can reject. That was just like untrue, but still, people who were like chosen obviously still had subconscious biases. The reasoning there is that people aren't trained as a juror to ignore those biases. Substantive then about why this is particularly harmful for certain types of victims. And the premise of this argument is that victims obviously deserve to be protected by the system. The negative does a lot of the work to suggest why this is true. Now, this system is already incredibly traumatic for a few reasons. Firstly, it looks like rape victims having to take rape exams and explain what kind of underwear they were wearing, explain why they didn't tell someone to stop more vehemently. Secondly, it looks like someone who was the victim of domestic violence who now has to take the stand and testify and relive that pain. That's the world that they stand for when they completely remove the avenue for plea bargains to avoid a trial. But we'd also note that it isn't just necessarily victims who don't want to testify. For example, the state can just make a decision that, for example, it is perhaps bad to go to trial because A, the victim is like, for example, a bad witness who is shaky. This is why this is also a win for us on justice, because assuming that a witness is bad on the stand, that is likely to hurt their case. When you now have the avenue to not put that victim on the stand because it doesn't hurt their case, you are more likely to get justice for that victim. Maybe someone isn't found like guilty or innocent, but like comparatively, in terms of sentencing, you might get a harsher sentence, or a lesser sentence at the point which a victim is bad for their case. That's why they couldn't just run away with victims. That's why this is a huge win for us, because A, we obviously avoid cases of trauma at the point which some people do take plea deals. But secondly, in the cases where a perpetrator might be even like completely let off guilty because a victim just like broke down on the stand, we think that we avoid that case at the point which a perpetrator now has the option to take a guilty plea. It avoids that victim from ruining their own stay. Note that they don't obviously have much choice here. They can be subpoenaed by the opposition, subpoenaed by the opposing counsel, which is why at the end of this speech, firstly, we won on consent, we won on justice and efficiency, but we also told you for victims and all the metrics they wanted to run, we won this debate too. For all those reasons, proud to affirm.
Opposition have tried so hard in this debate to make this about whether juries can actually do their job properly. But what we think is a more important thing for them to answer if they really want to run with that case is whether it is justified to concentrate judgment to the hands of a small and powerful elite group of lawyers and judges which only come from a certain subsect of society which by and large is not relatable to anyone else on that stand. So 3 questions we need to answer so far in this debate. Firstly, this question of a power asymmetry. Secondly, do lawyers act in good faith? And thirdly, what is the solution to the so-called Ecuador problem? But on this problem of the power asymmetry, what it's ended up being is 2 questions that I've got to answer. So firstly, what was the opposition's characterisation of the legal system? They basically said that they valued the expertise of lawyers over the relatability of juries. I've already told you in intro that that is by and large a bad thing to say because it is unrelatable to the minorities, to the individuals that come forward to be judged, and it is unfair for those individuals who don't have a same relatable experience. But note that No, thank you. But secondly, what does this mean for the nature of the legal system? Well, we would say that actually means that there is going to be a trend towards a lesser degree of proof. Note, we're not saying that lawyers are not going to want to do their job properly, but what we're saying is the nature of the jury systems means that you tend to overprove things. What this means is when you have to take away the need to explain things to such a high degree that you can convince multiple people of diverse social linguistic backgrounds, you're probably actually going to have less degree of proof and probably actually less less effective mechanisms of investigation. We say that this is harmful because it reduces the quality of investigations, which means you can actually prosecute less crimes in the long term. But on this second question of do lawyers act in good faith, I think this is actually quite an important one. So firstly, let's just ask, what are the incentives of lawyers? I don't think we ever said on our side of the house that lawyers just don't want to do their job. I think we more said that they're overworked and they are probably not going to, and if you give them the option of being able to use plea deals, they're probably going to gravitate towards that even at a subconscious level. But even if you don't buy that, let's just have a look and say, how do plea deals change the norms of incentives relative to lawyers? This means that once you normalise the use of plea deals, lawyers are probably going to be more likely to use them, because when it becomes a normalised thing to do because of in the nature of efficiency, as we've been told down opposition's bench, we're probably going to see more uses of plea deals and less carriage of justice, which I will address in my substantive contribution, is actually a harm to the development of justice in a society. But let's also look in this final question of what is the solution to the Ecuador problem. Note, we believe that Ecuador is outside of the context of this debate. We think it is too harsh a burden for us to prove why we need plea deals in Australia and in the rest of the world. But let's just engage with it anyway and ask, well, what is the Ecuador problem? We state it is a problem of a corrupt and undeveloped legal system. Note, the plea deals would actually probably worsen the position of these individuals because they're probably going to also be manipulated into bad plea bargains they probably shouldn't be taking anyway. No, thank you. But, sorry, let me have a look. Where am I at? How do we actually do... The problem is an undeveloped underdeveloped legal system. So how do we actually develop these legal systems? Well, we say that we do this through two ways. Firstly, investing through world organisations such as the UN to actually develop these legal systems instead of just forcing more people through these corrupt legal systems and not enforcing change. Where do we think that this change comes from? We think that at its worst case, even if the UN's not there, we think because there are corrupt trials that can be seen to be corrupt, we actually have media attention and we have discourse on these corrupt areas. But we think even this means that there can be change that can happen without the silence of plea deals. If a plea deal is happening in a corrupt country, you don't know that the trials are corrupt and you're less likely to actually see attention and demand for change. I think, however, a more relevant example was one of the New South Wales family trials. But even that in itself was a bit harsh. I think they were trying to take advantage of we don't have knowledge of New South Wales law coming from the NT. But I think it's better to note that we're probably not going to see plea deals being used in family courts. It's a bit of a weird concept, and there is outside of court settlement areas that you can take. We think a more relevant example would have to be criminal courts, and we think that those are fundamentally I don't think you can argue that those are not functioning in Australia, but even if you say, let's say worst case that they aren't functioning, I'm going to outline in my substantive contribution that we make them more functional through having more cases to improve case law and increase the amount of judgments going through our courts. I'll take a point.
Does individual choice ever play a role in the legal system?
What do you, it's difficult to understand what you mean by that, because they're asking individual. Actually, I think I get what you're getting at. So, individual choice is really coming up in the terms of plea bargaining. Should you have the choice to plea bargain? Well, I think they're completely disregarding the fact that you can plead guilty as it stands. We think the unique harm of a plea bargain means that you can be manipulated into making choices for the wrong incentives that perhaps don't benefit you, and it is also fundamentally getting around the system for reasons that are not contributing to the correct passage of justice, and instead only for private gain or for the gain of your lawyers. So on the point of substantive, I've lost my sheet. Okay, the problem is, how do we develop justice? Now we have 3 questions to ask under this point. Thank you very, very much. That's the wrong one. Okay. What is the development of justice contingent on? Why is this benefit not symmetric under their side of the house? And why is this a priority in this debate? So on this development of justice, what is it contingent on? Let's ask 3 questions under this subpoint. The principle of case law, why this principle stands, and thirdly, what happens when you don't have this principle. So let's look at the principle of case-based law. This is the use of cases to create precedents to inform future cases. This looks like all courts being bound to the precedent of courts higher to them, or at the very, very least, being influenced by the choices of courts around them. We think that is a very powerful mechanism that is usually upheld, especially in Australia. But why does this principle stand? Well, let's just say, essentially it's because it keeps up with the developments of society and it keeps the legal system honest and more relevant to individuals over time. This makes for more case law generated, means more up-to-date interpretation, which makes more relevant outcomes. Now, why is this not happening without plea, in a world with plea deals? Because we fall into the pitfalls of case law, which is that, in a world without plea deals, you fall into the pitfalls that are often seen as the negatives of case law because it's not being updated. We think that the fact that we can update law and we can add contributions is what protects our legal system from becoming outdated, and by actually having plea deals, you remove that single one most important thing that makes our legal system so functional and so just. But why is this not symmetric? Well, the problem is, by normalising plea bargaining, you reduce the amount of cases going through court. It's a pretty simple idea, but at all levels, this also creates less precedents to inform courts of their judgments. No, thank you. No, that even if opposition still maintains some cases going through courts, we still have more. So we have a more benefit, and we say that the more rapid development of our legal system is always a benefit for those who have to face it or go through it, or even, as we noted at first, those who have to interact with it, and it creates more trust, which we don't think has been responded to adequately on the opposition side of the house. So why is this a priority in this debate? Well, firstly, let's ask, how many people can this affect? This can affect everyone who has an interaction with the legal system at any point in their life. We think that itself is very important. But secondly, who does this affect the most? We say this is people who come into contact mainly with common crimes and the common courts. So why is this development of this single area of common law most important? We say this is most important because most people will actually go through these areas. Most people will either have to be a witness, they'll be a victim, or they will be the person facing charges in the common law system. We think that because these people are the most likely to be affected, and probably also less status, so they can actually they actually can't pay for higher paid lawyers to win more cases. We think that they are owed a higher degree of properly executed justice, which can only be achieved through a trial. Because of that, because we protected the legal system and we gave you all of these reasons down our bench, we're so happy to negate.
Fatal blow to this opposition was dealt by their own blade. Because if it is true that lawyers are bad at explaining a single concept of a plea bargain, then it is obviously true that under their side, where you have to run a months-long case or even years, that they are unable to explain the law over and over again, which means that this opposition team can't run away with the debate by saying that lawyers are bad because they have to use lawyers as well. And in fact, bad lawyers actually harm the cases far more under their side. So, two questions I'm going to answer in this speech. First, can people consent to plea bargains? Second, are plea bargains a more efficient and preferable form of justice? On the first, can people consent to plea bargains? So the first thing I want to explain is why this issue is particularly important. And that's for two key reasons. Because this opposition team continually tries to avoid this and explains that choice doesn't really matter. There are two reasons you should care about this. The first thing to note is that even if opposition can explain that plea bargains are harmful sometimes, the fact that people consent rationally means that people are unlikely to take plea bargains in those cases, and they are likely to use them in cases which are beneficial for them. The second reason why this is important is because even in opposition's best case, where they win lots of the practical material, note that this principle is sufficient for us to win the debate, because people consent to decisions which are perhaps suboptimal for the examples that we've given you, i.e. we don't force you to take a case to the court, even if that's something the justice system might say it's good. We don't force you to represent, you can choose to represent yourself even if that's something that we think is bad, but the fact we allow that choice demonstrates that you're able to take a suboptimal decision that is within your right to represent yourself at court. So, at the end of that, it's clear that this is a particularly important issue, and this opposition's failure to respond to this is particularly damning. They say three things. The first thing that they say is that people don't understand the law, and they therefore can't make this decision. The first thing that we explain first is that we're able to provide that information. Lawyers are able to do that. That's within their obligation and their legal rights. Second, people interact with law in multiple ways all the time, and it's unclear why someone who would care about going to jail wouldn't do any sort of research at all. The third thing that we'd say is that even if this is true in their best case, people would still, if it is true that people do not understand the law, then they do not understand the law under your side, where they have to go through the trial process either, so it's unclear that they get any sort of benefit on this. The second line of attack is to suggest that lawyers are simply bad at their jobs, but we provide a variety of incentives to explain why the people doing this job are likely to be particularly good at it and why they're likely to actually care. Firstly, because public defendants are not corporate lawyers. They're not there for the money. They want to help the people. They care about them, and that's what we see. But second, because they have a reputation, and even if they care about future career prospects, we think that the fact that you are winning cases is clearly good for those prospects. They are likely to do this well. The third thing that we'd say is that if you believe that is true, then that lawyers are particularly bad, then obviously having a bad lawyer is much worse in a trial because the process is extended, which means that lawyer has far more influence in that, and that bias comes through all that, how bad the lawyer is affects that trial a lot more than just happening at one certain point at time. The final line of attack is to suggest that it's coercive simply because you want to reduce your jail time. First, we would say all decisions have an allure. Having an incentive to do a decision is not a bias. That is making a good decision which is in your own interest. Second, this can't be coercive for the reason that we're simply adding another choice, which is to say currently you don't have this choice at all. We're giving you another option, which means that we think that people are able to consent to this the same way they do in the number of other ways that we've told you down the bench. So, at the end of that, what's clear? People can clearly consent to this decision, and this is an important and pivotal part of this debate that this opposition has ignored even when we POI'd them multiple times down the bench. So, then on the second question, are plea bargains an efficient form and preferable form of justice? I'll take you now.
Yes. Do you believe that the defendants should be informed to make informed decisions about their case? Do you not believe that under our model, where the court system is transparent, they're able to more effectively learn about the law and understand it?
So, if your complaint is about lawyers cannot explain plea bargains, then it's unclear why, under your side, they can explain the whole minutiae of law that happens in a months-long case over time and time again. And if that is true, then we think that the bad lawyers that you guys speak of affect that case far worse, and we think that it ends up worse on your side. So, second question, are plea bargains an efficient form and preferable form of justice? I'm going to talk about this in two ways. The first thing I'm going to talk about is efficiency. The second, I'm going to talk about opposition's material. And the reason I'm starting with efficiency because this opposition totally underweighs the impacts which we give you from first. They concede from first that this is something they're willing to lose on, so all we have to do to make this a huge win is impact this in a particularly big way. Because we note that getting efficiency is something that's particularly important, because the people who wait in jail are those who can't pay bail. The people who sit in jail because they're not able to pay the huge expenses to like go home, and instead they have to sit in jail and suffer. And note that those perhaps low SES people who can't pay for bail are not people who are guilty. They're sitting in jail because other people are going in front of them. And often that means that because they are breadwinners, they're the adults of their families suffer as well. The people who's like the people who have the jobs in the family are sitting in jail, and all those families suffer, even though those people may not actually be guilty. That is a huge harm in this debate that this opposition has not dealt with, and they've actually conceded from first. So that's not only a principled harm, but we would also know that's a practical harm to those people, their families, and all those people who spend a minimum of 3 months in Australia waiting for that trial. That is decades of people sitting in jail when they should not have to, when they are not guilty, and that is destructive to this opposition and takes over their argument as well. We've already proven from first that this is something that's particularly important, and this opposition's failure to respond to this is damning for their case. The second part of this that I'm going to talk about is how fair will the trials be. And the first thing that I want to talk about is their claim that you don't trust the law when it's behind closed doors and accountability. Because they try and make a meal out of this, but there's a huge number of missing links in this argument. The first thing that we note is that given their own characterization that these are not high-profile cases, it's unclear why everyone is like watching these trials for the plea bargains that they talk about. But the second thing that would say is that it's a huge logical leap to think that people are going to stop calling the police because their plea bargains now exist. For example, you could choose not to take the plea bargain if you don't trust the plea bargain. But we would also suggest that if there is a crime committed, there is at least some justice done under our side, even if you think that perhaps it is not perfect, even under this best case scenario for opposition. The final thing that we'd explain is that this is obviously contingent on their trials being more fair, which we've explained is unlikely to be true for the reasons that we've given down the bench. That is the fact that the long trials are particularly resource heavy, which makes it more imbalanced. That is for the reason that if you think that biases exist, those biases happen more when there's a panel of 12 people who are more likely to have those biases rather than judges and lawyers who are trained to get rid of that bias. So the final thing which would say is I'm going to deal with the specific material brought out at second negative, which they try to sort of fiat in. Because they say that they would counter fiat things about corruption. The first thing that we note is that as this is a support debate, they can't fiat things in, particularly at the time at second negative. They have to give reasons why those things are likely to occur, and they haven't done that. The second thing that would say that this, even if this is a solution, it is particularly slow. That is to say that under our side, we're able to get these benefits immediately. And every day this opposition is unable to fix that corruption. That is more people sitting in jail day after day for crimes which they may not have committed, salaries taken away from people who will suffer that this opposition has not dealt with. Their final line of attack is one of precedent. There are two responses here. The first thing to note is that by their own analysis, this precedent is unlikely to do anything because if there are low courts, then the precedent doesn't carry down much. But the second thing that would say is that it's unclear that this is the tipping point of change for the reason that to the extent that some cases still go through this court, it's unclear why perhaps the thousandth and first case is the one that suddenly changes the precedent on how we deal with a specific crime. So at best, this is incredibly minimal impact. But what you have to weigh that against is people who sit in jail and suffer when they may not have committed that crime. Which means that even in this opposition's best case, where perhaps our justice is imperfect, the comparative they have to deal with is people not having justice at all for long periods of time. People sitting in jail and they should not have to. So, at the end of the speech, what do you know? We win on consent, and we think that people can make decisions even if they are not perfect. But second, we think this is better for justice. This allows people to get through the court system in a way that has never happened before, and this opposition is clearly down with that. So proud to propose.